Hello friends, welcome back to the channel. In today's video, we are going to revise the chapter of CA Interlaw, which is Prospectus and Allotment of Securities, by using a keyword-based revision approach, which is properly exam-oriented. Friends, most of the CA aspirants are properly understand the whole concept of a particular provision, but they lose mark in the area of writing, as on the time of writing they do not incorporate the concerned or desired keywords by the ICAI. So in this video we will revise the entire chapter by using exam focused keywords based revision video, which shall be exactly you need to write on the time of your examination. So without any further ado, let's get started. So before starting, the first we need to divide the whole chapter due to simplicity. So we can divide this chapter into two parts. One is for public offer, which consists of section 23 to section 41, and private placement, which consists of section 42. I hope this partition is very clear to you. We just divided the whole chapter into two parts. This doesn't imply that we leave any section or we give more focus on any particular section. We read everything which are provided by the ICAI in this CA Inter course. However, for the sake of simplicity, we just dividing the whole chapter into two parts for just sake of simplicity. Correct? Next. So let's start with the first section, which is section 23. Section 23 stands for public offer and private offer. In the case of public company, the shares can be issued by such public company by way of four alternatives, which are public offer. Public offer means they issue prospectus to the public at large and raised funds through the prospectus. Second is private placement. We will read on section 42 in this chapter. Next is right issue. Provide the share to the public at large in considered price or in such price which is derived after considering. Or next, bonus issue. Bonus issue means the company, there is not a fresh issue or not a share issue. Rather, I prefer to say the company just want to capitalize its reserve and surplus, and therefore instead of providing you the amount of dividend, they what to do, they extract the amount of dividend from its reserve and capitalize the same to its share capital. However, in the case of private company are eligible to issue its share among the public by bonus issue, which is, as discussed earlier, the same concept. Right issue is such issue which shall be such issue which is under the market price. Or private placement we will read in the section 42 in this chapter. However, the private company is not eligible to create public offer or to issue prospectus to the public at large for the purpose of raising such fund, as this is a private company. The facility of private public offer is only laid on the hand of public company. I hope this point is also clear. So moving ahead with the next area of this chapter, which is the definition part. Before starting this, I want to tell you one thing very clearly, that if you don't understood the concept of core definitions, then you will not able to proceed with such chapter. And for this purpose, you need to develop the concept of a particular definition, which are core definition in nature, and that's why I divided the each and every portion of a particular definition into small identical parts, which will help you on the time of revisioning, right? So let's start with the section 2, clause 81, which is the definition for securities. So securities is a wider term and include how what things are include the blue areas you need to check out include the shares, the bonds issued by the company, the debentures, the derivatives, the unit of collective investment schemes, the security receipts, the unit of mutual fund, the government securities. These all are includes. This means these are the inclusive definition, not exhaustive. This is inclusive definition. However, it doesn't include the unit of ULP, ULIP. ULIP means unit linked insurance policy. Correct. So let's revise once again. Securities 281, securities 281 is a wider term, and put and provision, right? Put and provision and include what things are to be included: the shares, the bonds, debentures, derivatives, unit of collective investment schemes, security receipts, unit of mutual fund, and government securities, and many more like this. Correct. As we have written etc etc after the government securities, means these all are the part of the security. However, we can add more components like this in the definition of securities. However, we should not include the unit based unit based ULIP, correct? Unit based insurance policy or unit linked insurance policy. I hope this definition is very clear to you. And if yes, then proceed with the further definition, which is for the definition of prospectus section 270. Section 270, what does it say? It said that any document as described, the same will be prospectus, or if this condition is not fulfilled, then we can check out the second condition, or issued as a prospectus. Any document I have issued as a prospectus, even if a single paper I have issued as a prospectus, the same shall be considered as a prospectus. And next is and include issued as a prospectus or any document as described as prospectus, any one of them. However, and include means any document described shall be optional, issued as a prospectus. We can pick up any one out of the two. However, whatever we have picked up from the two components, we need to also add the portion of include as and is written behind include. So and includes red herring prospectus, RHP, shelf prospectus, and any other notice, circular, advertisement, or any other document who inviting offer from the public. It means such document by which I raising the fund from the public at large. The same shall be also considered as the prospectus. Now, one question may arise: what is the definition for red herring prospectus and what is the definition for shelf prospectus? In this situation, I want to suggest you to please wait. We will read these also in this particular chapter further. Correct? So for this purpose, just understand the definition of prospectus. I hope all of the definitions are super clear to you. And by assuming the same, let's move ahead towards our next section, which is section 24. Section 24 stands as power of the SEBI to regulate the issue and transfer of securities. Basically, in this section, we will learn about the power attached with the SEBI, or SEBI, or for what reason SEBI has been authorized. So by pronouncing the name of this particular section, we can understand that SEBI is the authority who have the exclusive right to regulate the fresh issues and transfer of the securities to one beneficiary to another. So let's identify one by one. The SEBI has the authority, okay, for the purpose of regulating the issues. It it can it can provide or prescribe several new laws which can be in the public interest for new issues and transfer of securities, for transfer of securities as well, and non-payment of dividend if the company declared its dividend or the same has been announced or advertised. However, the company later on were unable to pay the amount of the dividend. So this is the case of non-payment of dividend. SEBI has the authority to create an investigation against such company in this matter also. By the listed company, who will be regulated by the SEBI? The company who are listed already or intending to get it listed. Otherwise, private company will be not under the purview of the SEBI. However, the same shall be listed or intending to get it listed on a recognized stock exchange in India, NSE, National Stock Exchange, or BSE, Bombay Stock Exchange. Correct. Next, moving ahead with the next section, section 25. Section 25 has document containing offer of securities for sale to be deemed prospectus. Basically, section 25 stands for deemed prospectus. So, what is the deemed prospectus? If a company allots its share or any other securities to an intermediary with a view that the intermediary will act on behalf of the company and the intermediary is able to distribute the shares among the public at large. And on the time of such distribution of shares, the company provided the document, whatever the document the company provided to such intermediary will be known as deemed prospectus. Correct? The detailed keyword is not in my voice, but to appear in your visuals. So my voice is working for understanding the whole concept. However, after understanding, for exam purpose, you need to revise the visuals, whatever you have checked in your screen, right? Or whatever I have sharing, correct? Next, moving ahead. Section 25 further specified that the matter for the purpose of issuing the shares to the intermediary, what provisions, what additional provisions I need to also remember. The provisions related to section 26. What is the section 26? We will read further, but just for instance, you may understand that the section 26 is a core concept of this particular chapter, and it provide the detail or the detailed regulation by which we can understand that what compliances we need to do for issuing any kinds of prospectus. So section 26 and its all provisions shall be followed properly. The net consideration of net consideration it has received from the public need to be prepare a detailed statement for this, and it need to mention a proper time and place from where the document can be viewed or inspected. Okay, next, in the case of deemed prospectus, who has the power of signature by which the document can be authenticated? So, in the case of company, there shall be two director, or in the case of firm, at least half of the partner shall be shall be authorized for signatories. Next, in the case of firm, we also need a one fact. Let's assume in a case of company firm X, there is a total number of 20 members, and such firm want to issue its deemed prospectus. So for this reason, at least 20 partners shall be provided their signatures for authenticate the same. Correct. So this is the meaning of at least half of the partner, and this is the minimum requirement. If and what is the maximum requirement of all director or all partner can be signed, then that the same shall be considered as the maximum extent. Correct. I hope the provision of section 25 is also clear to you. And if not, then I would recommend to pause the video and again check the portion of section 25. This is very crucial area, and you have any kinds of doubt, then you may mail us on the dedicated email ID provided in the description of the video, or you may put down the comment below with your queries. Now let's focus purely on the provision regarding section 26, which is the matter to be stated in the prospectus. Now before starting, let me clarify one thing. In this in the chapter of the prospectus and allotment of securities, the section 26 is quite relevant, and this is important as well. So you need to be very conscious and careful while listening the provision of section 26. However, Section 26 provides several conditions for the purpose of issuing the prospectus by any company. First, the prospectus shall be dated and signed, and the date provided in the prospectus shall be deemed to be the date of the publication. It means your prospectus as an official document must carry on with the prescribed date in the front of the page. If there is there is no date, then the prospectus shall not be issued until such date has been inserted. However, the date you have mentioned on your prospectus, the date shall be considered as the prospectus shall be published on such date. However, or whatever the fact that the prospectus is issued before or after such date, but if a date mentioned on a prospectus, the prospectus shall be deemed to be the issue of publication the same date. Okay, moving ahead. The section 26 states that the prospectus shall be signed by which the authenticity can be ensured, and the same shall be signed by all director, and if there is existence of any power of attorney by the director, then such power of attorneys shall also be authorized for putting such signature. Further, the company shall submit its financial report in such manner as the SEBI, in consultation with CG, may prescribe. Or if there is no such provision mentioned, they need to follow the provision as prescribed by the SEBI. Further, the company shall also attach a copy of declaration where no contravention from the end of the company has been recorded on the time of performing such compliances. Further, prospectus shall be submitted to the office of the registrar of companies before issuing the same to the public, and the same shall be issued to the public within a period of 90 days starting from the day when the same was delivered to the office of the ROC. It means you need to submit or deposit your draft prospectus to the office of the ROC, and after submission the same to the office of ROC, you are provided with a time period of 90 days, and within such time period you need to issue such prospectus among the public at large. Next provision of this section is related to a expert statement. It means you have to hire an outsider as an expert. Such experts shall not be engaged in the PFM. PFM means P stand for promotion, F stand for formation, and M stand for management. Promotion, formation, or management of the particular company. The same shall not be included in the PFM of the particular company. Besides, the expert shall provide a written declaration based on which he has found by reviewing the prospectus. His personal opinion is very required or crucial in this area, and the same shall be attached with the prospectus. I hope this I hope this section is also clear to you. And if yes, then let's moving ahead with our next section, which is section 27, variation in the terms of the contract or object in the prospectus. Basically, the section is want to say that if a company raised fund with the help of prospectus, and on the time of issuing prospectus, the company need to write down the proper reason by which it is raising fund from the funds from the public. The fact is that it needed to be written on the time of issuing such prospectus. Now, on the time now after raising fund or after conducting the whole process, the company is of the view that the particular reason cannot be fulfilled or the particular reason shall be modified. Then what are the provision? Or then first question may arise, shall arise, whether a company can do so, and if yes, then what are the condition for doing such thing. Such condition is provided by section 27. First provision is the company shall not vary any terms of the contract. Contract means the prospectus or such document. Any cannot vary such term of the contract as referred to in the prospectus except it has passed or it has taken prior approval by passing special resolution. SR means special resolution from the general meeting, and the same shall be deposited, or the same shall be advertised in the body of the newspaper. I have written two just beside the newspaper. It means the company need to prescribe, or the company need to advertise on two newspaper. First is English newspaper and the second one is vernacular newspaper of such place, or of such local place from where the registered office of the company is belonging. And if company have any kinds of website of its own, then it shall also publish the same on its own website. However, the company cannot use such amount towards buying, trading, or otherwise. BOT, buying, otherwise, or trading. Buying, trading, or otherwise, dealing in the equity share of any other listed company. It means after issuing fund from the by using the prospectus, the company shall not invest the same on any other company, any other listed company for gaining some extra profits. No, this is completely against with the provisions. The funds the company has been raised for the purpose of self improvement, not for investment purpose. So this purpose cannot be fulfilled. However, if any shareholder of a particular company is not agree with the with such variation, then such shareholder shall be provided with the exit offer, and such shareholder will be termed as dissenting shareholders. So the dissenting shareholders will be provided with several exit offer by the promoter or other controlling shareholder in such manner as the SEBI may prescribe. The dissenting shareholder need to be get out from the company if they are not aligning, or if they are uh, not providing their consent related to such variation. I hope this is very clear. Next, moving ahead with our next slide. Under section 27, the whole fact which we have already read is mentioned under Rule 7 of the Company's Prospectus and Allotment of Securities Rule 2014. Rule 7 and the number of rules shall not necessary for remember, but you should try to remember the same, correct? So, what is the Rule 7 is expressed. Rule 7 is also telling the same fact that special resolution shall be passed with the help of postal ballot. In the chapter of management and administration, when we will provide the separate video for management and administration, we will learn about the type of votes. Postal ballot is a one type of voting method, right, which can be generally used. Okay, so special resolution shall be passed with the help of postal ballot. The advertisement of special of the board meeting shall be provided in the format of PAS1. This is the e-form number in the form PAS1, and this is the advertisement, and the same shall be pasted on the newspaper. Next, place the notice on the website of the company and the newspaper of English or two vernacular or one vernacular language. Next, the dissenting shareholder shall be provided with the exit offer by the promoter and controlling shareholders in such manner as the SEBI may prescribe. So the same thing it has been mentioned second time, but in this time the same is mentioned on Rule 7. Now, moving ahead with our next section, which is section 28. Section 28 is basically want to provide the condition associated with offer for sale. Correct. So the keywords I have also written in your visuals. Correct. So you need to copy such keywords from your visuals which have been appeared in front of you. But I just want to express you the main reason, or the you may say the main fact of this particular section. So sometimes what will happen? Let's assume in a company X there are several members, which is Mr. A, B, and Mr. C. Now, Mr. C is the holder of 20% of equity share in the company X, and Mr. C wants to sell out certain portion. Let's assume 5%. Mr. C wants to sell out the 5% of its total holding among the public at large. And for this purpose, instead of going outside or going the marketplace by itself, Mr. C propose the company for conducting such manner or conducting such events by which Mr. C can dispose of his 5% of stake among the public, and the total consideration can be got credited in the account of Mr. C on account of Mr. C. So for this purpose, the collective action taken by the company is called the procedure for offer for sale. And after conducting such event, the amount of net consideration will be credited by the company to Mr. C. And in exchange of the same, Mr. C mandatorily reimburse the expenditure incurred by the company only for these purposes, only for fulfilling these purposes, need to be reimbursed by Mr. C to the company. This is the whole procedure for offer for sale. I hope this is very clear to you. And the main keywords is in front of your visuals. If this is clear, then let's move ahead with further section of section 28. Now, Rule 8 of the section 28, Rule 8 of Companies Prospectus and Allotment of Securities Rule 2014 is provided several exception to section. It means the the provision associated with the minimum subscription is not required for conducting offer for sale. What is mean the provision of minimum subscription? Read uh, we will read later in this particular chapter. Minimum application value, receipt of minimum application value, this is also not relevant. Creation of statement or preparation of statement of utilization means utilization certificate by the BOD is not required here. Any other provision as may be prescribed by Companies Act 2013, the same shall not be applicable for in the case of section 28. However, the prospectus shall mention the name of the person or the entity who actually bearing the cost of OFS. In our example, Mr. C received the amount. It means Mr. C want to dispose of part of his holding or full of his holding. So if Mr. C conducting the process with the help of the particular company, then Mr. C shall be liable to bear the expenditure, and the name of Mr. C, the full name of Mr. C, shall be written on the prospectus that he is the person or he is the person, yes, he is the person conducting such no selling or disposing of his portion of share, and he shall be the responsible for paying off the expenditure borne by the company. I hope this is also clear to you. Next, moving ahead towards our next section, which is section 29. Section 29 stands for public offer of securities to be in the demat form. It basically want to express that if you as a company want to publish your share or want to yes want to publish your shares, then the same shall be conducted with the help of a demat account. No physical format shall be applicable here after a particular date. We will read hereafter. However, if any share you as a company have been issued in physical form, the same shall be converted into the demat format. So let's understand the definition carefully. In this section, every company then view the green area. After every company, check out the green areas. Every company making public offer and other class or classes of company. Every company means who? The company who making public offer alongside means including the other class or classes of company as may be prescribed. So these are the definition of every company. What they will do? Again, check out the yellow area just below the every company. These green companies means the companies prescribed on the green slide or green boxes shall issue its securities only in the demat format. So which company? Such company who are taking initiative for conducting public offer and any other class or classes of companies as may be prescribed. Next, in the case of prescribed class of unlisted company, if they have several security which are held or which are already held, then the same shall be held in the demat format, and the process of transfer shall be conducted with the help of demat format. And as per the Depositories Act 1996, the actual format of dematerialized account is prescribed. And any other company are also allowed to convert their share into demat form or issue their security in physical form. They can issue their security in physical form, but later on they need to convert the same into demat format. I hope this is also clear, and if there is any doubt, you further provide us the mail or put comment down. Okay, next. Rule 9B of the Company's Prospectus and Allotment of Securities Rule 2014, demat for private company. In the previous slide, we have read what we will do or what is the role for unlisted or prescribed category of unlisted company. Now we will read with the help of Rule 9B what the private company shall do. So the private company other than small company means private company other than small company shall on or before 36 2025. This is the deadline. Or after this date or before this date, the act have been amended retrospectively. On or before 36 2025, they can issue their securities only in demat form and facilitate the facility of demat for their all kinds of securities. That's all. I hope this is also clear to you. And let's move ahead towards the last section for the day of this chapter, which is section 30, advertisement of prospectus. On the time of providing or publishing advertisement, you shall state the following areas. You shall state about the following areas, which is objects, which is your liability, which is your total number of authorized share capital, which is the name of the signatory, means the name of such person to whom you have provided the power of authentication, your details of existing subscribers, and your total capital mix, means your total balance of the liabilities as compared to its assets. That's all. So, yeah, that's all for the today's video, and I hope each and every provision you all properly understood. And if there is any kinds of doubt, then you may mail us or you may put comment down, or if there is no doubt, then we would request you to solve the questions from whatever questionnaire you have. Solve the questions in detail. First of all, understood the concepts from these visuals and my audio, and after that try to memorize the same, and after memorizing try to solve the answers. Correct? Fine. And if you like the video, then you should actually show us by pressing like button on the YouTube. And if you don't like this video, then you may put dislike also. We have no objections, but this will be also our motivation for doing better for our next day. However, before leaving this channel, do check it out, the description section, where you can find a link for Google form. Fill out the form and suggest us based on which chapter we are required to prepare video, of course, before finalizing this prospectus and allotment of securities chapter. We have also mentioned our email ID in the description section. Once again, just information purpose. If you have any kinds of doubt or queries, please check it out. So, check it out. Such email ID, we will definitely try to answer your doubts. So, with this note, I am Shantan Jana signing off for the day. Have a good day. Thank you very much.